But first, Friday was a day set for high drama as Henry Keogh's daughter and his father travelled to Canberra to see if the High Court would agree to reopen his appeal. Evidence that false and misleading facts played a crucial role in his conviction is now undeniable. It's just a question of how to get it to court. For Alexis Keogh, whose father's been in jail for more than half her life, it seems an odd kind of justice that puts legal technicalities ahead of getting to the truth. Graham Archer has more.
It's a long road when you're on your own.
It was a journey to Canberra for Alexis Keogh and her grandfather Henry Sr., full of hope and dread.
And every new town just seems to bring you down.
Kind of like 12 years of frustration and disappointment and anticipation, all just amounting to this. So
it's come down to one moment, really, hasn't it?
Pretty much. And I'm nervous but hopeful that they're going to get it right this time.
In fact, it's been a 12-year journey, always destined to end up in the hallowed halls of the High Court of Australia. How would you sum up the way the South Australian system has treated your father's case?
Well, the fact that we're in Canberra 12 years later speaks for itself that they haven't done their job.
On Friday, the High Court met to decide if Keogh had run out of legal options in South Australia.
I've been wanting closure for 12 years, but the thought of it actually happening and it being not what I've expected and hoped for is a pretty daunting fact. So, yeah, I'm not sure if I am prepared for it or not.
The guarantee of a fair trial is the basis of a civilised society, and yet successive South Australian governments have wanted this case buried, regardless of the obvious wrongs, and partly because
it's a complete Pandora's box, Graham. I mean, if they lift the lid any higher, how many more might pop out? How many more Henry Keoghs are out there?
As most South Australians know, Henry Keogh was convicted in 1995 of drowning his fiancée in the bath for $1.2 million worth of life insurance, having signed her name on a series of policies. Circumstantially, it was a compelling case for the then DPP, Paul Rofe QC, who took on the prosecution personally.
I think it was a combination of a lot of evidence that was led at trial.
It was a juicy story from the very start. The deceased, Anna Jane Cheney, was an attractive young lawyer. Keogh, the older man, divorced with 3 children, and who was accused of having a series of illicit affairs, though his family always maintained his innocence, dismissing the insurance as a tragic coincidence.
Well, while we were married, as a matter of convenience, Henry always signed papers for me, and he had my permission to do that, and I had no problem with that. It was just a matter of convenience.
He faced a media lynch mob, depicting him as a despicable cad who'd killed his devoted fiancée for filthy lucre. The local newspaper even declared him guilty hours before the actual jury had returned any verdict. And when they did, it was another sensation. A hung jury. The first trial had ended in a stalemate.
After 10 hours of deliberation, the decision ended in deadlock, the jury unable to deliver a verdict.
Despite the prejudicial press, the judge sent him back for retrial just 2 months later. Keogh was doomed. However, due to the work of a small group of concerned lawyers and supporters, and a 6-year investigation by Today Tonight, we now know the juries in the 2 murder trials were not told the whole truth.
It's hard to imagine a matter more serious for the legal system than something of this sort.
To really understand the magnitude of this discovery, we need to go back to 1968, when the state recruited an inexperienced and underqualified forensic pathologist from England, Dr. Colin Manock, to head up the department.
They said, we knew we were taking a bit of a risk because we were appointing somebody without proper qualifications, but it was our view that he would get the qualifications after he was appointed.
Once the boss, he refused. The key skills he lacked were in the crucial area of histopathology, the study of tissue under the microscope, essential in conducting autopsies, the very crux of his job. Dr. Manock spent the next 27 years doing over 9,000 autopsies and giving crucial expert evidence in some of the nation's most controversial cases, such as that of Fritz van Beelen, who spent 17 years in jail for a murder he claims he didn't commit.
On the surface, I might appear to take it calmly, but inside of me, I'm eating my guts out.
Dr. Manock speculated that Keogh had drowned his fiancée by grasping her legs and lifting them over her head while pushing her head under the water. His evidence relied on small bruises just above the left ankle, which he claimed betrayed the existence of a telltale grip mark, which he discovered during his autopsy.
I placed my left hand behind the lower leg and found that I could fit my 3 fingers and thumb against the bruises that were present, so that it was possible it was caused by a grip.
The die was cast, the thumb bruise on the inside of the calf being the conclusive forensic proof of murder. The juries were told by the DPP it provided
the one positive indication of murder, namely the grip mark on the bottom of the leg.
The trouble is, we now know the thumb bruise didn't exist, and with that, the prosecution's entire forensic case should collapse. What Keogh's lawyers have in vain been trying to put to the courts is sworn evidence that Dr. Manock and his colleague Dr. Ross James knew at the time that they were misleading the juries, committing red-blooded fraud, as the High Court were told.
That's a very strong claim, isn't it? Oh, look, I mean, you couldn't have a stronger claim that strikes at the very heart of a criminal conviction.
Despite undeniable evidence of that, and the ever-growing body of expert opinion asserting the case was seriously flawed, few in government, media or legal circles here want to know about it.
We've had a petition before the government and we've been before the medical board and we've been waiting even longer. We've been blocked or delayed all along the line.
Led by Attorney General Michael Atkinson, for whom miscarriages of justice don't fit his government's hyped-up law and order agenda, Atkinson has been prepared to misinform Parliament and the public about the case at every opportunity.
If he allows political considerations at all to influence his decisions as the first law officer, he is failing in his duty and he's failing the people of the body politic to which he belongs.
And there've been plenty prepared to assist the Attorney-General, who also have a vested interest in keeping the lid on this disgraceful episode, including numerous attempts to discredit experts like Tony Thomas for having the courage to expose the truth.
That was a pretty dirty business, wasn't it? Yes, it was. It was a very shabby affair.
A quick look at what's gone on should shock South Australians. The medical board took 5 years to review the quality of Dr. Manock's autopsy. When it did, Dr. Manock made his appalling admission about the crucial bruise.
So he looked at it, thought it might be a bruise, put it under the microscope, couldn't find any scientific evidence of a bruise, but said it was a bruise anyway. That's correct.
Though their own experts found his work incompetent, the board gave Dr. Manock its tick of approval.
The reasons for the decision are exactly what I expected. They were disappointing and perfunctory, and they haven't dealt with the issues.
It took another 2 years before the decision was quashed by the Chief Justice with the damning judgment that the board had used the wrong test for unprofessional conduct. By then, 7 years had been wasted.
If you have a tribunal that doesn't know how to ask and answer the right question, then plainly it doesn't know what it's doing.
But the evidence of problems with the prosecution case continued to mount. Today Tonight engaged the services of a photogrammetrist who was able to calculate the exact depth of the bath using the police photographs, something the police and Dr. Manock failed to do. Allowing for displacement, we were able to confirm there was not sufficient water to cover the nose and mouth of a person Anna Jane Chaney's size.
On that evidence alone, it kind of knocks the prosecution's theory out the window, doesn't it?
Yes.
During all this, the Attorney-General had his lawyer, the Solicitor-General Chris Karakis QC, deal with Keogh's petition for mercy. It ended in a secret report and a press conference from which Today Tonight was shamefully excluded.
It is not arguable that there has been any miscarriage of justice.
The outcome was no surprise, and on Friday the state, via the DPP, again blocked the damning evidence from being heard. Martin Hinton QC appeared for our DPP. Back in 2001, he'd written this article about the evils of non-disclosure of evidence.
If an accused person has been prevented by fraud, malpractice or misfortune from presenting evidence of substantial importance, he's been deprived of his right to a fair trial.
Strangely, those high principles didn't get a mention, and the High Court, clearly not appreciating the nature of our Attorney-General, decided Keogh could still get justice in South Australia. It was a bitter blow, made more so because, again, the decision had nothing to do with the actual facts.
The incompetence of so many people, in the forensic field particularly, and the evidence that was given has since been disproven to not even be true evidence. Like, how can a conviction stand on that? I don't understand. I don't know how you can make sense of that.
But it's by no means the end, according to Keogh's barrister Kevin Borrick QC, who says the way ahead is for a fourth petition of mercy, which will inevitably be unreasonably rejected by the Attorney-General.
The court has virtually said that we've got the right, if the government don't send it on, that we've got the right to have that decision reviewed by a court.
South Australians need to understand why this case is so important. If the conviction is allowed to stand, it means it's okay in this state to withhold and falsify crucial evidence, admit to it, and still get away with it. Surely that can't be acceptable anywhere, especially in our own home. The only people who say there's nothing wrong are those who are themselves part of the problem.
What you've got in Keogh now is some very, very well-credentialed expert evidence which casts enormous doubt on the very fundamentals that convicted Keogh. And in my view, that is the sort of case, it's the archetypal case to go back before the court.
Graham Archer with that report, and as always, we'll keep you up to date with any development. Now, when we come back, a candid chat with John Howard and Peter Costello, find out what they really think of each other right after this break.